Sales tax at 7% on the chattels. Some years ago, the retail sales department gave out a little sort of clue sheet as to what they considered taxable and what they considered not taxable. And your broadloom, if it was laid over a subfloor, was not taxable because it was part of the real property. If it was laid over hardwood, it was taxable because it was a chattel. Your dishwasher and dryer and so on, if they were built-ins, they were part of the freehold. If they were freestanding or movable, then they were chattels and there was tax. But the one I've never had the opportunity to use is the one about the gutters in a bowling alley, and I've never had the chance to say, oh yes, that's taxable. However, anyway, welcome back, and I am hoping that those of you who have any questions will write them out, as one gentleman has done, and we will try to answer them, as many of them as we can, and as best we can. Since those of you who have come have expressed an interest in fairly basic work in the real property field, I don't want anybody to go away unhappy feeling that you haven't learned what it is you came to learn. So if we've missed something, please give us a chance. We've got 4 more weeks. And if you're dissatisfied, we don't want to hear it, but we want to hear it. We would like to hear what it is that is not satisfying you, because this course is to help us all. And one of the things I'm very anxious to learn about is about a survey. And I'd like to introduce you to Lorraine Setterington. And Lorraine, all these people came to hear you even before they knew you were the first woman surveyor who was a woman. They are anxious. I hope you're going to tell us a little bit about what a surveyor does. And I'm not exactly sure what a surveyor does, but I'm told that in the olden days it had something to do with a chain and a jug. That may account for some of the discrepancies in our surveys. Anyway, Lorraine started off as a teacher, and at the moment we're going to put her back in her teacher's role. From then, she took her education as a surveyor, which, as in our profession, includes articling, and practiced as a surveyor, has also done a good deal of teaching in her field, and at the moment is the executive director of the Ontario Association. It is also a self-governing profession, and I suppose POC wants to get a crack at it too. Anyway, I'm very anxious to hear, and I'm sure you are, Lorraine Setterington. Thank you.
We used to have to pass the test on sobriety too, but they, thank heaven, took that out. After listening to Brenda, I think one of the main things I want to do is to make sure at the end of the evening that you realize why costs have to be set aside for surveying. And to paraphrase an expression of Will Rogers, it isn't what you pay a man, but what he costs you that counts. And I think that is the whole name of the game here. Not necessarily cutting out necessary costs, but realizing what costs have to be set aside in the interest of the client. I'm going to go through pretty well the paper I did present. It's a short paper, doing a bit of side talking through it, and then I want to discuss how to look at a plan, a sketch, certificate. I will make a resume of my comments on that and have it to Miriam so that you can be given next week. And if there are any written questions, I'll try and have a resume of those also included in the comments, which you will get next week or the week after. I think before I can make any discussion on what a survey is and what you should provide when you have a real estate transaction, you have to realize we have a problem of defining the word survey. There's a guideline for real estate transactions, and in it it says a survey is a drawing of a property prepared by an Ontario land surveyor. Incorrect. It's not necessarily. There is no definition of survey. Many misunderstandings of the word are in existence, and there's no definition in legislation. The closest we have is in the Surveys Act, which states that no survey of land for the purpose of defining, locating, or describing any line, boundary, or corner, or of a parcel of land is valid unless made by a surveyor or under the personal supervision of a surveyor. So basically they're saying there that the survey is the defining, locating, or describing, but only that that's the purpose of the survey. It isn't the whole survey. The word survey, as you well know, is used very indiscriminately by all of us, and it isn't clear to the layman. I'm sure it isn't clear to the legal profession. It isn't even clear to the surveyor what a client wants when he phones up and says, I need a survey. My lawyer told me I need a survey, and I need it right away. I have people who phone up and say, I had a survey done and I didn't get a plan. a plan isn't necessarily part of a survey. So the word survey, as I say, it's very difficult. And before we attempt any definition, I'd like to review what the surveyor does when he sets out to survey a parcel of land. One myth: there are no rules and regulations any more than there's a set of rules and regulations on how you go through each individual court case. The surveyor, and as you will notice we go through, is involved in an awful lot of the same things you are: the assessment of evidence, the research, the same type of work that a lawyer has to do. Many acts and regulations, such as the Surveys Act and the Land Titles Act and the Registry Act, have regulations appended to them. Those regulations cover the size of the plan, the type of ink, the size of the monuments, etc. But they do not set out strict procedures for surveying. The surveyor is mainly involved in 4 areas in his profession. Number 1, he establishes new boundaries, and I'm sure you've all been involved in this. That is, he marks out in the ground and defines on paper by either plan description, being the reference plan, or written description, the shape and size of new units of land. Generally, the owner has some idea of what he wants. He's probably had to have a severance approval, and the surveyor acts more as a technical consultant in this matter to create the visible land parcel. He gives opinions about the quality of existing boundaries, considered on the basis of evidence of those boundaries. The parcel that was severed 50 years ago, or 100 years ago, or 200 years ago, or perhaps only 10 years ago, either by written description, by registered plan, compiled plan, or whatever. Or possibly even by the farmer pacing down the road, going to the local conveyancer and drawing up the description, forgetting that he stopped to talk to Zeke halfway down the field and lost track of his number of paces, and the property isn't even anywhere near where he thinks it is. The surveyor reestablishes existing boundaries if they have become lost, obliterated, or confused, again using the best evidence. And he creates new boundaries to replace those that he simply cannot reestablish. It has been stated in the Land Titles Act that the description of registered land is not conclusive as to the boundaries or the extent of the land. And I'm sure all of you know that descriptions and evidence might not agree. Even a casual glance at the many antiquated descriptions still in the registry office would have to drive home this point. The regulations under the same act state where a monument no longer exists, all evidence concerning its original position shall be considered in the reestablishment thereof. And those 2 statements about the description and the boundaries not agreeing and the reestablishment of the position of the original monument probably tell more definitively what a surveyor does than all the other acts. A lot of people think the Surveys Act, because it has a huge amount of regulations appended to it on how to reestablish boundaries in township surveys, is the surveyor's Bible, and it certainly is not. All the regulations attached to the Surveys Act basically refer to the reestablishment of townships in Northern Ontario, because they're always considering that no evidence has been found in your running line on an original township. The Surveys Act basically doesn't apply to Southern Ontario at all, because in Southern Ontario there is always an abundance of evidence, in fact quite often too much evidence, in order to do the survey. And the Surveys Act says very specifically that you first consider all the evidence, and if there is no evidence, you go to the methods that are outlined in the Act. So as I've indicated, the first function of the surveyor is to set new boundaries. Initially, these boundaries were set for one owner, that being the Crown. The township fabric was surveyed by the early surveyors under adverse conditions using basic equipment and local help. I just gave a talk last Tuesday to the Ontario Museum Association, and we got into some of the conditions that they worked under. And a surveyor in the late 1700s, early 1800s never had any technical help with him when he went out to survey. He hired it all locally, and his general concern was keeping them sober enough day to day to do the work. And often only the front posts were placed in township lots. The sidelines were seldom ever run, and the rear lines never in the early systems. The settlers themselves were held responsible for the establishment of the interior lines of the farm lots. One of the early conditions of receiving a grant of land was that you did have your sidelines run. And I was in practice, in private practice in surveying and engineering in Leamington area for 10 years. And there, the evidence of the early running of the lines is quite evident, because if you've been down in that country, you know it's flat as a table. And the fences are die straight most of the time. And they definitely were run by someone. We can't prove by whom, but they are the only evidence of those lines ever being run. And any surveyor would be very foolish to go in there and disagree theoretically with those fences that have been there and have been on those farms for probably 150 years. And they are a good example of being the best available evidence of the original line, the only evidence of the original line. The purpose of surveying in those days was to get the settlers on the land quickly. The standards of surveying, although criticized by many today, were exceptionally good considering the conditions. Too often, and I often get asked why the distance across a single lot farm, or single farm lot is supposed to be 1,980 feet, and why it isn't, and why won't I survey it to be 1,980 feet? Well, unfortunately, that's the theoretical distance. The distances that we find now probably will be more than that. They're very seldom less. But the tolerance or standards for surveys have changed considerably in the last 200 years because the value of the land has changed. There was no need when they were back using those old Gunter chains that were made of 100 links, which kinked as they went through the bush. And if they didn't kink, they stretched if they pulled them too hard. And you couldn't tighten them up if you were going across a gully because they were chains. They weighed a tremendous amount. So this has now resulted in, with the expensive land prices, etc., that the property, which is now worth a tremendous amount of money, is going to come up with a different result at the time of the survey. Once the original parcels are severed, whether it be original township lots or new lots in a registered plan or in a subdivision, the surveyor becomes involved in the remaining three aspects of his profession. That is, giving advice concerning the existing boundaries, perhaps going out and finding the original posts or bars or stakes, whatever was put in there, perhaps remonumenting it, putting in the bars again. Or if he cannot reestablish it, creating new lines and having, together with the lawyer, those lines declared the true lines of the parcel, perhaps under the Boundaries Act application. In all of these, the surveyor has to consider the best evidence. It comes as a surprise to many people that the surveyor does not go out when he's trying to reestablish boundaries to place his new bars where the original monumentation was supposed to have been placed. In other words, he's not going out there and saying, the original deed said it was 100 by 150, and I started over 520 feet from the lot line. His job is to place the new bars where the old bars were, regardless of whether or not they were put in the right place originally. So if somebody goofed on a 100-foot tie-in originally, the surveyor is to replace the monumentation where it was placed the first time. So he has to ascertain the original lines and the original monumentation locations. The laws of evidence, as they pertain to surveying, are first thing that has to be taken as a natural boundary. If you have a description of a property that goes from a limit of a highway to a lake, you go that distance regardless of what the measurement is in the deed. If it says from, and you know the old ones, from the highway to the tree, that is how far it goes if the tree, of course, is still there. Or to a stone, etc. The natural boundary, that about which one is least likely to make an error. The second law of evidence is that you take the original monument. That is, the monument that is undisturbed and can be proven to be in its original location. And again, remember, we are stating the original location, not necessarily the correct location. The third law of evidence is evidence of possession or evidence of where the monuments were. By using surveyor's field notes, old records, be able to reestablish where the monument was the first time, although it's no longer in existence today. The surveyor has, under law, right from the early 1800s, been entitled to obtaining field notes from any other surveyor in the province. We are not allowed to say no. Any surveyor can come into our office and ask for the field notes not the plan which belongs to the client or the records or the file, but the field notes of any survey we have done, and we are obligated to provide those. So quite often the search by the solicitor or by the layman for the original surveyor really doesn't matter, because we can get those notes. And it does say a reasonable fee. I have a couple complaints a year on what a reasonable fee is, but generally it's $25, $35 for the field notes for a survey, and a lot of firms interchange notes at no cost to each other. So the evidence of the possession or the location of the original monument has to be assessed, and it has to relate back reasonably to the time of the original survey. So possessory lines on the ground, including fences, lines of trees, old axles, hedges, trees that have been planted after, and the old fellow says that, you know, it's in the place where his grandfather planted it, sort of thing, have to be followed out. And the last thing we come to, the last piece of evidence we can use in doing a survey, are the measurements and bearings that are contained in the deed or are shown on the plan. So that is the last thing we have to look at. Quite often the public thinks it's the other way around. So this leads us back to the point, I think, where we can discuss just what is the relationship between my profession and yours when you're acting in a real estate transaction, in fact, probably at any time. I think the landowner or the purchaser has to depend on both of us to tell him if he has a good title, and if, in fact, his boundaries on the ground agree with that title, not where they ought to be necessarily, but where they are. Too often we find that the only role relegated to the surveyor is to provide a print of an outdated plan. I go through at least once a day, if not twice a day or more, phone calls from law offices, quite often from the secretary, sometimes from the lawyer, asking where they can get a print of a plan that was prepared in 1952 because they're closing tomorrow. I like to always ask if they are using a 1952's title search that has not been updated, because I think the question is very valid. I have had lawyers who have got very snarky with my help, because my secretaries, because they cannot give information on people who have been suspended from the association. And I try and say, if the man's been suspended for incompetence, I suggest you don't get his old plan. But purchase, I know I was in private practice. It's a logistics problem. They always tell you at the last minute they want to close tomorrow. As you said, they're out in the car at 11 o'clock at night. The 11th hour, you find out you need the survey plan. Our profession has, because of our problems with clients and problems in the profession, now taken the attitude, and I think we'll be acting a little more together, that prints of old plans will not be provided except to the original client or an authorized agent. And if the firm is providing prints of the plan because they feel they have the right to, if they cannot certify as to its current accuracy, in other words, is it complete, a disclaimer will be placed across the face of the plan of each print, and I think you'll find these starting to crop up in the next couple of weeks. We studied it well last year. We had our legal counsel study it, and we felt that with the problems we are having brought to us by the public, we had no choice. Too often a surveyor is asked to survey the parcel as described in the deed, and no monies are allocated for proper research. And I'd point out that the surveyor, in taking on a survey, has to, and it's been found in the last few years that he's been found liable if he did not do a title search, separate and apart from the title search done by the legal firm. He again has to do a search of survey records in offices. In Metro, or in the South Central area here, it isn't too bad because they do have a computer index that is available only to the surveyors, and they, instead of having to phone up 60 offices to see who has field notes, they can look up on the computer input form or output form and see whether or not, see what offices have done surveys. However, it only goes back about 15 years, so any work prior to that, they have to find themselves. They also have probably a half dozen regular agencies they have to contact regarding street lines, Boundaries Act plans, municipal surveys, etc. So this time has to be taken. Quite often, any suggestion that more than the original deed should be looked at in doing the survey is dismissed as unnecessary or too costly. And I'm sure you would not or do not often certify title by examining only one deed, and the surveyor finds himself in the same position. For him to certify on a plan the boundaries of a parcel, he needs the funds to properly research and survey the parcel. The registry office search, although many of the surveyors, and as I said, I surveyed in a small town, we cooperated with the legal firms in that we would use the title search that they did and then also do a small amount of checking up in addition to it. The surveyor is looking for different things when he's doing a title search. You can usually tell by reading a description whether or not bars are even mentioned in the description, whether or not a surveyor has drawn it. And of course, as soon as you go through and pull out the deeds that have been drawn by surveyors, they can then follow up more closely the research onto who has been in the area, what property they have surveyed. The advent of reference plans has in some ways greatly facilitated the ease of preparation of descriptions of many-sided parcels of land, but I was into a case yesterday where the land has been owned by so many people and none of the developers have progressed with what they were going to do, that now they're sitting with about 8 reference plans on top of one another, of course all with different parts, and the draftsman I was looking at was trying to prepare one sketch showing all of it, and I wouldn't want to have to do any conveyances on any of those because they are going to be absolutely out in left field. When I began this talk, I stated that there was no definition of a survey. However, we have to come to those items that are always talked about: a plan, a survey, a sketch, and a certificate. I think the reference plan now is well known to all of you because it does represent a total survey, total boundary survey showing all encroachments, all occupation, all evidence. I think more and more people are using reference plans, whether a reference plan is required for their particular transaction or not, simply because a plan of survey is virtually the same as a reference plan. Not many more dollars are required to change a plan of survey into a reference plan. There are certain items like showing the instrument numbers of adjacent properties and that you normally wouldn't put on a plan of survey that you put on a reference plan. We've had one problem with putting the instrument numbers on the reference plans, and we've taken this up with MCCR because several problems in the province have been written into us where the lawyers had taken these as being the last registered owner, and of course the surveyor is not taking that. He didn't feel he was taking that responsibility on. Perhaps he is. So a plan of survey is a fully monumented survey with all the boundaries being defined on the ground by bars or witness bars. It may show all structures within the parcel, encroachments, overhangs, easements, discrepancies between title and what is on the ground, any overlaps, gaps, etc. A plan of survey. Well, what is a mortgage survey? There's no such thing. There soon will be, because the new regulations under natural resources are going to indicate a mortgage survey in the monumentation regulations. Too often, a surveyor is asked only to provide a survey or a plan or a sketch showing the house on the parcel, period. And this is not, a mortgage survey is not a survey. If I have a person phone up the office and say, I'm very upset because I paid to have a survey done last year, and then they'll go into their problems, the first thing I ask them to do is read the title block. If the word sketch appears there, I said you didn't pay for a survey. And that's why you and I have to communicate. They are not paying for a survey if the word sketch is on there, because no surveyor is going to call a full survey a sketch. It's one of the things to look at. If your offer to purchase says that the vendor has to provide a plan of survey, don't accept a sketch. You're not getting it. Some of the old plans showing building locations that were prepared 10, 15, 20 years ago would now be entitled sketches. And basically, someone asked me yesterday, a solicitor phoned me yesterday, and he said, are you saying that a person could have prepared a plan, a survey, or a sketch showing the building location and only showed the house on the property when there was other things that were there sitting that he should have shown? I said, yes. It was quite common, and in some areas it still is common, for the order to be, I want a sketch prepared showing the house on the property, period. I don't want you to take the time to do the fences or the overhangs or anything. The mortgage company is only interested in knowing whether or not the house is on the property. So just because the plan doesn't show encroachments doesn't say they aren't there. And when we go through how to read the plan later, I'll tell you some of the clues as to being able to tell whether or not you do have the full survey when you get the print in your hand. To simply provide a sketch using the minimal amount of background evidence can result in a document, although it shows the house on the property, will not show whether or not the fence across the rear of the property is encroaching by several feet. It will not show easements that are not on title if they're not in the same deed, and it will not necessarily show any encroachments or overhangs on buildings that are adjacent to the property. Then we come to that last thing, the mortgage certificate, or, as it was known in Toronto for years, the drive-by. That's about what it's worth, a drive-by. You could drive by and look at the house and write the certificate out yourself, except the mortgage company won't accept it. And that is, if you're paying $100, that's about all you're getting, is a drive-by. The surveyor sees the lines and he has a thing. All he's saying is the house is situate on the parcel, period. This is a typewritten certificate stating that the house is on the parcel. It mightn't say another thing. Some of them get into a lot of details. You might as well have a plan if you're getting into a lot of details. The certificate, again, is not the result of a full survey, and therefore, in my opinion, and I think our profession is beginning to take this attitude, we're shortchanging the purchaser. We think that a mortgage certificate should only be used probably in those instances where you have the house out in the middle of the 50-acre field. And it would seem too costly to go and have to survey the 50 acres to tell the mortgage company that the house is out there. Sort of the hitting against the wall that we're beginning to find. Just read you a few excerpts on a continuing saga of letters I'm getting between a law firm and one of our surveyors. The lawyer says, when I was talking to you on the telephone, I was somewhat surprised that you do not do surveyor certificates. Not many years ago, we did not have to bother with these things, but someone in the survey business seems to have altered the finance and trust companies. I wish we could have. He went on to say, we get the certificates, this is a lawyer speaking, for about $100, and they satisfy the trust companies. We turn out to be the good guys because we save our clients money. I'm surprised you were unaware of these things, but obviously the solicitors in your area are not concerned with their clients' money. Obviously, this is the start of it's going to go on forever, and every time they do it, they send it more carbon copies to more people. I don't know who's going to, you probably will get on this list one day if this continues, because it's getting longer each time. Surveyor in writing back said, the person who says, oh, by the way, I need a surveyor certificate, has no idea of what he needs. Probably the real estate agent has scurried around and phoned the local survey firms and hasn't been able to find a plan, and therefore has said, well, why don't you get a certificate? Most surveyors are not, as I say, going to be providing surveyor certificates. I think we're nickel and diming, and they're fine if everybody knows what they're getting, but I'm finding that the public does not know what they're getting when they get a surveyor certificate. They see the word survey, that they've been provided with a survey, because see that even if you write surveyor certificate, they interpret that as survey, and therefore they've been misled. In my position with the association, I deal with the public constantly, as I'm sure the Law Society does, and I receive phone calls from people who have purchased homes, and on a regular basis, or we receive letters. And they assume, as I said, that they've paid for the survey. And they now want to put up a fence, and there are no bars. The neighbor has a survey, or the neighbor puts up a fence, and it's a foot onto where they thought their property went. Or they want to get a building permit, and the garage that wasn't even shown on the mortgage plan at the rear of the property is too close to the line, and they can't add the change house for their pool. And right away they come back and said, why not? I paid for a survey, why didn't I have all this done? Well, as I say again, I have to state that they probably didn't pay for a survey. They probably paid for the lowest amount, the cheapest amount, to get enough to satisfy the mortgage company, which is not, in all instances, a survey. It's my contention that the purchaser should have a clear understanding of not only the quality of the title, but the extent of his boundaries at the time of purchase, not after. In order to do this, a proper survey must be provided. And the solicitor in this regard must indicate to his client why this is necessary. Thousands are spent on real estate commissions, and yet little is spent on determining whether or not there will be problems with the property in the future. And you notice I didn't make any reference to lawyers' fees. That's right. We also have guidelines, or suggested guidelines for fees. I point out that the surveyors across Canada have more or less said that they're going back to very strong suggested guidelines on fees. We find the public wants to know the approximate cost of things. And we refuse to tell them. They, of course, feel we're covering up rather than following the Combines Investigation Act. And we certainly haven't found that it's been in the best interest of the client to keep silent about what the fees are. I've mentioned earlier about the old plans, and I won't say any more on that right now. I would reinforce that providing the mortgage certificate or a sketch is not providing the client with what he may need in the future, and too much can be severely risked because of this. I think the surveyor has to be far more vocal in his relationship with you, and the mortgage survey has its place, and will always have them, and the certificate, but limited, not the rule, the exception. How are we going to work together? Well, I hope more evenings like this. I know we're wanting to make surveyors available for any bar association or law society regional group or area group that needs an after-dinner speaker, etc. We will provide them. I think the lawyer has to demand, if he does not get it, a full report from the surveyor on the property. The day is gone when you should be handed the plan and the bill. Unfortunately, our profession, especially in the years gone by, have attracted those individuals who like the rugged outdoors and do not like having anything typed in the office. The day of consumerism, that's changing. We have to give the full report. Too often the client thinks that the surveyor takes away land. Somewhere in this province there's a tremendous amount of valuable land that we've taken away. We've always felt, I guess, that our plans are so clear, there's no need to explain them. I've had a client write in, and I looked at the plan. It showed possible adverse possession. It showed all sorts of contradiction between what was on the ground and the title, and the surveyor said he didn't send in a thing. The plan said it all, and he said, my bill said it all. His bill said to surveying services rendered. But to us, the plan is so clear, and we're trying to get across to our members that not everyone finds it that way. And, you know, it has to be demanded that a report is given on that plan. Remember, the surveyor is giving a professional opinion. Surveying is not a technical art, as engineering at times might be. Engineering surveying tends to be a precise or technical profession. Surveying is not. We're giving a professional opinion as to where a boundary is after we weighed all the evidence. I think you can use your surveyor far more for advice regarding the solving of boundary problems. The quitclaim deed, I think, thank heaven, is going into oblivion, and some of the more lasting methods of solving boundary problems are being used. The surveyor probably is more knowledgeable about the workings of the Boundaries Act and the quick expedition of that act if there is no conflict between neighbors, and it is a good tool on clearing up title. We must remember that, as Justice Cooley said, every survey can be challenged in court. And it would be nice if we could just simply weigh it and see whether it's right. But too often, not only don't the parts add up, but the surveyors disagree. And as members of the legal profession, who I'm sure disagree with each other at times, you can realize that this will always be acceptable. Two surveyors who, if we find that they have weighed all the same evidence and come to a different conclusion, is acceptable. But please don't ever hire a third one, ever. Okay. Now, I mentioned in looking at the plans, I'd like to give you some hints as to what you should look at. I don't have the long one from Spates. Do you have the long one there? the long one. I've got the short one. Yeah, can I have this one?
I haven't even got the short one. The short one,
Okay. If you're handed a plan, and I'll use, or document of any type, and you want to ascertain whether or not it is a full survey, and this is what your purchaser is entitled to, and the word survey by itself should be construed to be a survey, a full survey, not a cut-down edition of a survey. The title block is the first thing to look at, and it should say plan of survey, or the word plan now won't even be used if it isn't a full survey. But if that word sketch shows up, or house location, or building location, right away you should twig that it probably is not a full survey. Those, I think, are the most indicative words. Sketch, house location, building location, or the word mortgage, a tall in the title block. Mortgage plan, mortgage sketch. You're getting an inkling that perhaps this was done by only giving the surveyor the one deed, and perhaps he was told to only put the building on the plan and not do the full plan. As I say, this is, I'm now talking about plans that have been prepared fairly recently. If you go back 10, 15, 20 years, they probably were all called surveys. But you look at some of the other clues as they come up to tell whether or not that was a full plan. Which way is north? Generally up the page. Please have your title searchers draw theirs the same way. Just have one surveyor going into a lawsuit now. The architect drew all his plans with north down, and the surveyor drew all his plans with north up. And they poured the footings before they found out. Generally, north on any plan of survey is somewhat up the page or on an angle, but near the, heading towards the top. Certificates on a plan. I hereby certify that this plan is in accordance with. That certificate is generally never put on a plan, or should never be put on a plan unless it's a full survey. But I hereby certify that it's in accordance with all the regulations. That won't appear on a sketch or a building location or a mortgage survey. It simply won't appear there because it doesn't comply. It does not comply. Generally on a sketch or a mortgage plan or a house location, you'll have the surveyor's signature with his name printed under it, but you will not have a certificate printed out in full. Are bars shown on the plan? Monumentation in the corners. If you have a plan that's a few years old and it says plan a survey, and there isn't a bar shown at any of the corners, I'd probably say that that was a mortgage survey, but it was prepared before the emphasis to entitle it properly came about. A full survey is monumented, or witness bars are shown, or there's a non-compliance certificate put on the plan saying that because of conditions, compliance with the monumentation regulations have been waived. But a full survey is a monumented survey, and the bars have to be shown on the plan.
What's a witness bar?
A witness bar is a bar that's because of a hole or a rock or something is placed so many feet away, and it just witnesses the other bar. The measurements, how to tell from looking at a plan whether or not you have a full survey. If you have a plan showing a house at the front of the property, and on the side lines of the property and the back of the property, it says 100 feet per deed, and that's all it says, you know those lines have never been surveyed. Or probably have never been surveyed during the course of this work for the plan that they produced. Because per deed is exactly what it says. It was in the deed. If it says deed, 100 feet, measured 99.9, you know he's both taken into consideration the deed and the measurement. So probably it's a full plan of survey. If it just has the distance, 100 feet, without deed or measured, it implies that the line has been measured. No qualification implies, because we don't go around putting measured all the time on our plans. We should only put measured when we're stating on the face of the plan that there's a disagreement between the deed measurement and the actual distance that we measure in the field. But again, I say if it only says per deed, per deed, per deed, it's a signal. Am I getting a full survey or not? Or am I simply getting the distances from the old plan or from the old description parroted on the face of the survey, and perhaps the only distance that's been measured is the front, and that will be put deed and measured. What does more or less mean? Always the problem. More or less should only be used when you're going from one fixed point to another. In other words, if I'm going from a bar planted in the limit of the road 100 feet back to a bar planted on the limit of a registered plan, I should put more or less, regardless of how precisely I've measured it, because the distance there is irrelevant. You're going to go from the road to the registered plan regardless of what distance is called for. So when that distance is put in, it should be qualified with more or less. How much is more and how much is less? In surveying, as in most professions where measurements are entailed, 100 feet more or less means within a foot, 99 to 101, because we're saying 100 feet. But if we say 100 feet 3 inches, we're within an inch. 100 feet 2 inches to 100 feet 4 inches. So take it down one more. 100 feet 3.5 inches should be accurate to within a half an inch. That should be the tolerance. Now that is, I'm only talking about tie-ins to buildings generally now, not boundaries. So that I always get very suspicious of a series of plans that comes up that was done years ago, and the setbacks are always 20 feet, 20 feet, 4 feet, 4 feet, 4 feet, 4 feet. I've never found a contractor yet who could put a house on a parcel of land and have it 4 feet from all, at all corners from both sides. You just cannot do it. It's impossible to do. The building shown. And that's why I took the plan of Spates, and it's done rather amateurishly, but I whited out a lot of it. And you have the long one, I think you had the short one that was available when you came in. And I took this back 20 years to 57 when the plan was first prepared, and took off all the things that wouldn't have been there then, and this is one of the reasons for not using these old plans. There certainly wouldn't be a hedge or a front porch. There wouldn't be a wooden deck or a garage or any fences at the back offline because it was a new house and a new subdivision. If it says under construction, it may have been located when the foundation was still 3 feet below ground level. It may have been located that soon, because quite often, especially now in these huge developments, the mortgage companies are pushing to get the plan as soon as the foundation is poured. And so by the time it gets up to 1, 2, or 3 feet below ground level, they're out there with the plumb bobs, which are the hanging things, lining it up to see where the foundation is. So the building, if it says under construction, may mean under construction when they're up to the first layer of bricks. They may have the right up to the top, but it isn't completed. Or it might be, as I say, a foundation a couple feet below ground level. Obviously, once that house is finished and there's any trim put on it or any facing put on it, the tie-ins, once that's done, are going to be different than when it was under construction. If there's any extras put onto the sides of it, they're going to be added after the under construction. It isn't going to reflect the same. And I think you can see on this plan how if you're using an old plan, many of the items that appear as people possess the land and use it are not reflected on the old plan. Certainly you could not indicate to the client, if you're using this old plan, about the board fence, which is not on the property line. This one only happens to be 2 inches out, but it could be 2 feet. The garage, which is so close near the bottom of the plan, and the eaves are projecting over to the next property, could be right on the line, or could be onto the neighbor's property by a few inches. You don't know because it wasn't on the original plan. So unless you ask for either an update by the original firm that did the first plan to do an update on it and give you a new plan, or you ask for a current survey, you aren't going to find out those things. You're going to be closing on the assumption that nothing has changed since the date of this survey. The matter of eaves and projections from homes is a regional difference in surveying. Where I surveyed, the mortgage companies did not want them shown. They only wanted the distance shown from the house, or the setbacks in the area on the planning and on mortgages where it was to be 4 feet from the main body of the house, or 5 feet or 10, whatever it was. Other areas say that any projection or part of the house can't be closer than 4 feet. If that was strictly enforced, most homes that are built would not agree with the regulations, because when they're building them, they seem to always build the main body of the house as being the 4 or 5 feet away. And it's a thing to watch if you have regulations or conditions that bind this property, and you're acting for the purchaser, that if it says any part of the house cannot be closer than 4 feet, to make sure that the plan does show the overhangs. Because the general plan showing a house like on either of these plans is the main body of the house. It is not the roof line. It's the main body of the house. It's another area to protect the client. I think that's all I want to say on that right now. Okay. The one on Holding and Jones hasn't, as I didn't white out one of these, but the same idea again. The frame deck wouldn't have been there. The wood fence on the production of the center line of a wall, and I'll tell you, it's very hard to build a fence on the production of a center line of a wall if you haven't the bar at the back. If it's been removed or it never was there, it's almost impossible to build that fence straight. The right-of-ways here between the two properties were probably in existence at the time of the original purchase, but the easement at the front probably wasn't. It probably was put on later. And if it wasn't in the same deed, then again, it wouldn't be reflected on the survey. And it wouldn't certainly be reflected on the first survey. Both these plans have been prepared as full surveys. They have the bars shown. And if you notice on Holding and Jones, they have the one witness bar at the front, probably because the property was under construction or being dug up for the sewer at some time, and they just had one bar witnessing all the front. But the bars have been put in at the back. What's my time? On page 23 and 26 that Brenda referred to, I just took a look at it, and again, we're talking ambiguously here. The words sketch and plan are being used together. And again, I'd really point out to you to be careful about that. They are not synonymous in surveying terms at all. Right on time. I hope by going over those items you have some insight into, I guess, our joint problems, and you also have some insight as to where we hope to go. I know some of the items are going to be difficult to change because most purchasers do not want to spend $300 or $400 or $500 at the time of a purchase to get a plan. You virtually cannot, and I don't think Brenda was too far out in her figures, get a plan, a survey on a residential property for less than $300 to $500. The lower figure if it's in a new subdivision, the higher figure, of course, if it's down in the old built-up area of town. I do hope that if there are any problems that you have or any questions, you'll leave them. And if we can ever be of help to you in your local groups, please call on us. Thank you.
That's it for tonight. We'll see you next week. Thank you very much, both our speakers.